Thank you, Mr Deputy Speaker. I rise to speak briefly regarding the Human Rights Bill 2018, as it has been well covered within this debate. As already summarised, the bill establishes statutory protections and compatible public functions for human rights, generally those included in the UN Universal Declaration and other UN and international conventions and declarations. The Anti-Discrimination Commission is now to be renamed the Human Rights Commission, responsible for promoting human rights and a public understanding and discussion surrounding, as well as addressing complaints. This is to be commended and appreciated. However, it is basically aspirational, as there is no legal recourse for contravention, with complaints resolved through negotiation only in the first instance. All future bills presented to Parliament will need to be scrutinised and certified by the Minister as to whether they meet these human rights conditions. This will add an extra level of process. Given the current frustration around the extended timeframes in government processes and agencies that are creating hardship for Queenslanders, we need to ensure that there is adequate provisioning for this to ensure efficiency without taking from other arenas. Mr Deputy Speaker, the 23 distinct human rights identified in this bill cover a broad range of what is seen as already in place, such as equality before the law, protection from torture and cruel, inhumane or degrading treatment, and freedoms of movement, beliefs and expression. Many are basics that are considered a standard: rights to health services, education and to a fair hearing. Others in which we are confronted with daily as problematic, including privacy and reputation, protection of families and children, cultural rights and security of person, may remain problematic without mechanisms beyond negotiation. There are some other concerns surrounding this bill, and I will touch on examples. The right to freedom of expression could present issues because what is acceptable or is not generally culturally and individually defined changes over time and in various circumstances. Similarly, the right to assembly and association and the right to privacy in relation to data collection, which is a current contentious issue. Mr Deputy Speaker, as well, there are a number of human rights Queenslanders would like included, such as access to the basics of living, affordable and emergency housing, and fair, economical and speedy resolution of their issues, including family disputes, to ensure the rights of children caught in the middle of these are respected. Public entities, as defined in the bill, including the NDIS, hospitals, universities, local government and government agencies, will need to function in a way that is compatible with the rights outlined in the bill, and this will require training and regular assessing, adding costs in already strained budgets. Some advocacy groups are concerned on certain clauses and wording, including education appropriate to a child's need, which could lead again to segregation and discrimination, not the inclusion sought, and that children convicted of crime must be treated in a way that is appropriate for a child's age. This assessment could lead to a child being incarcerated with adults and is an arena that requires clarification. Mr Deputy Speaker, in closing, while I support the aspirational nature of this bill, I am uncertain of the level of practical protection that this bill is capable of providing. However, given the provision for future reviews within the legislation and opportunities to address these concerns, if taken, will strengthen the capabilities of the bill without diminishing its admirable intent. With this in mind, I commend the bill to the House.
Thank you, Member for Noosa.